Bill Henshaw here, Constitutional Crisis Channel. And this will be a little different than what we ordinarily do because I had occasion to get some negative feedback from some of my recent videos, which is not something I'm used to, and it's not something I object to. Those of you that have gotten documents from me and we've gone back and forth in email know that I want you to check everything that I say. And you're going to find out 97% of it is dead bang right online. I don't make anything up. I don't say it if I can't prove it. Now, I don't know a lot of other statutory gurus out here who are doing anything like that. And a lot of them have the same mindset as attorneys and think you're the stupidest piece of crap on the face of the earth. And we know all the stuff. We've been to law school. You know, I'm tired of this kind of condescension and BS. And it's about time we end that, too. And I can guarantee you they don't get away with that, trying to use it on me. And they can tell you in Columbia, South Carolina, that didn't work very well at all. So that said, the negative feedback I wasn't upset so much by as the fact that it was insulting and degrading, and the person involved, and you know who you are, didn't cite any support for her position, which basically was that I was engaging and advocating a quote-unquote redemption scam. Now, any of you that has any or all of my documents, you will look in vain to see the word redemption anywhere in there. It's not an issue I raised at the present time. And the reason is because I'm not comfortable with it yet. I may be 80% of the way there. But that's not nearly good enough as the 95+% that I would need to be able to tell you that I'm comfortable with this and you should be too. There's no guarantees in this corrupt system, mind you, but if I get to around 95%, I'm comfortable with that. I'll go with it. I'll put my own life at risk as I did in South Carolina with the issues that I advocate and practicing what I preached. I walked out of there. So that's why I don't go with that one at this point. There's some stunning details about that you're going to love when I do get around to it and prepare to pick documents for it that'll be in a separate document packet. So that said, this person just didn't have a clue, as to what I was talking about. And, those are the ones I get in trouble by, because if you don't know what you're talking about, you shouldn't be talking about it. So if you're going to send criticism, please feel free to do that, make comments, suggestions, direct me to cases or authorities that might seem to contradict what it is I'm doing. And I will usually get back to you fairly quickly, and more often than not with other authorities that I use that counter the ones that you have found. I can't say that I'll do that 100% of the time, but don't be surprised, because there are some nuances here that when you understand the Ashwander doctrine, and we're going to do some more videos on that, and the rules of the court for status and standing, then you get where it is I'm going. And once you get that mindset, then it'll become much clearer, and you'll rarely, if ever, find any contradictions in what it is I do. That's part of the power I have, and the part of the power you can have by doing exactly that and not straying from that relatively narrow line that will get our cases reviewed in the Supreme Court until we get back, to what Chief Justice Marshall said in Cohens against State of Virginia about that, where he said that no matter how small a claim man's claim on a state, nor how little interest the community in its outcome, the framers of our Constitution thought it important in the interest of justice to create a tribunal as superior to influence as possible in which that claim might be decided. First time I read that one in the stacks in the libraries I used to do a lot of visiting to, I cried, which is not what you normally do when you read a law book. That's the way it's supposed to be. And now the Supreme Court is telling us all that we'll hear your case if we want to. There's nothing mandatory about it. Not true. That's another thing we have to get changed there. And say, wait a minute, when we come into the court and we bring our status and standing, whether that's a de jure jus sanguinis state citizen, or whether it's an alien, because we may all have been reduced to a status of statelessness, when we show up, that's our court. And you don't tell us what to do in our court. We make the rules, and the rules are the Constitution for the United States, 1787 to 1791. Anything that goes contrary to that is immediately preempted by the Supremacy Clause, Article 6, Section 2. I mean, anybody who's been to law school for 4 or 6 years and doesn't know that didn't get much of an education. I mean, that's so dead bang simple. Again, the classroom full of fourth graders are going to understand this one. So that said, I encourage all of you to do what I said. Check my sites, check what I'm doing. If you can find any errors in it, I'm always pleased to hear that, because once in a while, things like that can happen. And what I want to do is improve my documents and make them the best and most bulletproof they can be, easy to understand for you, and as difficult as possible for the DA to refute. Thank you.